It's quite an honor for me to introduce our next speaker, Professor Jerry Kang, who comes to us tonight from the UCLA School of Law. Dr. Kang receives his JD degree from Harvard Law School in 1993, and he's currently an associate provost at the UCLA School of Law, where he also holds the Korea Times Hanguk Ilbo Endowed Chair in Korean American Studies and Law, and he's also a professor in the Asian American Studies. Now, Dr. Kang has received many awards, and again, too many to list right here, but just to give you an idea of the kinds of awards that he's received, I just want to mention that he was honored with the Rudder Award for Excellence in Teaching at UCLA. He received the University Distinguished Teaching Award, the Asian Pacific Islander Heritage Award for Excellence in Law, the Korean Community Lawyers Association Outstanding Community Leader of the Year Award, and he is a recent David M. Friedman Fellow. So you can see that his stellar career expands on many different dimensions. Now, one of Dr. Kang's major areas of teaching and research interest is civil procedures and race and communications. And we'll hear tonight about this specific interest that sits at the crossroads of implicit bias and the law. So again, it's with the absolute pleasure that I introduce to you Professor Kang.
So it's an absolute pleasure to be here. I'm not a psychologist. It sounds corny, but some of my best friends are psychologists. It's a complete privilege to actually speak in this lecture series, and especially with my friend and in some ways mentor, Tony Greenwald. The title of my talk is Arc of Intent, How Psychological Science Should Inform the Law. The subtitle suggests that psychological science, indeed any kind of science, should inform how we actually make our laws and apply them. And for the past 10 years, I've been forwarding a particular school of thought that I call behavioral realism. To call it a school of thought is slightly an exaggeration because the steps are really, really easy. There's only 3 steps. Number 1, identify new science. What do we mean? Scientists are really smart people. They're constantly identifying more accurate models of how we think and how we behave. And as the experimental sciences discover these new theories and new explanations about how our brains work, that seems to be really interesting. Number 2, we should excavate old law. Now, law always has embedded within it a bunch of common sense assumptions, a sort of folk psychology. Law could not operate otherwise. Think about tort law, think about criminal law. What you're trying to do is incentivize certain kinds of behavior, punish other kinds of behavior, have moral statements about what's right and wrong. It's all the way through law. Psychology, in some sense, is unavoidable. Now, most of it wasn't drawn up with anything like double-blind experimental studies with good meta-analyses and effect sizes, but there's always a common sense understanding of how human beings behave, what's right, what's wrong, what counts as self-defense, what counts as premeditated murder. There's always a folk psychology within the law. Step number 3 is actually also simple, but in practice it gets actually tricky. When you have new science and you have old common sense assumptions embedded in the law, the 3rd step of behavioral realism is to account for the gap. Look, if the gap is sufficiently large, right, if we have a totally new model of how we actually think and behave as compared to what was built into the law a long, long time ago, then we should force the law to account. We should force lawmakers to say, look, we've updated our data, we have a new set of facts, we understand the world better, let's make sense of the world in a different way. Now, that could happen in a couple different ways. Most obviously, maybe the law could change to be responsive to a new set of facts. That seems to be the rational thing to do. Any business would work accordingly, and certainly you would adapt your own behaviors in accordance with new facts that scientists or health professionals might have told you. But I also recognize that sometimes the law cannot. Sometimes facts will be found, and sometimes the law will have to say, you know what, we can't change, notwithstanding these facts. I don't want to suggest, even though I'm going to be talking about science, I'm going to be a fan of science, I'm going to be a part of the reality-based community, evidence-based civil rights, I don't want to suggest that somehow facts always determine what our laws and policies ought to be, because it turns out facts are meaningless without values, and values are a different kind of conversation. And I can give lots of different examples. A crazy example is the following. Suppose we lived in an expressly religious society that turned on one holy text. Suppose that holy text stated in it that the earth is only 5,000 years old, notwithstanding the fact that that same society might be scientifically sophisticated, using sophisticated methods of carbon dating, that turned up evidence, you know what, we think the science suggests the earth isn't just 5,000 years old. It's still plausible that a society could say, you know what, even though the best science shows that the Earth is older than 5,000 years, for various reasons, we have to believe and act as if it were only 5,000 years old. We will act on that because it is who we are and our values, and we'll do so transparently. So what I'm trying to suggest is I'm only requiring a very thin response, right? I'm not asking a lot from the law. I just want you to actually adapt with new information, or at least just own up transparently why you can't change, even though the best factual account has been updated. So this is a thin normative account. I'm a law professor, so I'm going to use these kinds of terms. It's a thin normative account. What I mean by that is I'm not saying you have to be left of center politically or right of center to be a behavioral realist. All I'm asking you to is to be not hypocritical. What I mean by that is the law has always presumed that it's making sense, that it's both efficient and fair in actually coordinating our affairs, deciding whom to punish, deciding whom to credit. And if the data change, if the underlying factual picture changes, it's just our job to update it or at least tell society why we cannot, and to do so transparently. So this is my vision of behavioral realism. It's not that radical, and to give you a concrete example, I'm going to go back to Plessy versus Ferguson and Brown versus Board of Education. I know that most of the people here are not lawyers, but even so, you might have heard of these cases. Plessy versus Ferguson was the case that stood for separate but equal, right? And the Supreme Court, in telling Homer Plessy that there was no equal protection challenge to the requirement that he sit in a separate train car simply because he was black, said the following. The fallacy is that blacks assume, quote, that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put that construction upon it. Talk about blame the victim, but that is the idea. Like, you think it's a diss, it's your fault, not us. Get over it. That's how we thought of it back in 1896. Brown versus Board of Education in 1954 changes that. It flips and reverses Plessy, and it does so using the following language. It says, quote, whatever may have been the extent of psychological knowledge at the time of Plessy versus Ferguson, this finding of harm to black children is amply supported by modern authority. And what was that modern authority? They drop a footnote, and it included multiple studies, psychological and some sociological, including the Dahl studies of psychologist Kenneth Clark. Now, this reading that suggests that somehow we went from Plessy, which said segregation was okay, to Brown versus Board, where segregation was no longer okay, and that was driven in part by new psychological findings, these modern understandings, maybe that's a naive reading, right? Maybe I'm reading too much into what the Supreme Court says, but I want to offer it as one method. When the science changes, when the facts change, the law has an obligation to respond in kind, or at least tell us why it cannot. So that's my way of thinking about how science generally, and psychological science in particular, ought to inform the law. But that's been, somewhat abstract. Let's try to apply it to a specific context, which is to think about the idea of intent, indeed the arc of intent. And I'm going to focus on federal anti-discrimination law. Now, many of you are not psychologists. I also know many of you are not lawyers. Can I just see hands, like if you're a lawyer, out yourself. Are you a lawyer? Oh, there are a lot of lawyers. Okay, sorry. So it turns out, keep it quiet. So there are some lawyers. I know many people are not. Assume that this will be a crash course in first-year law school as well. And so you'll be learning lots, and I'll try to be comprehensible along the way. So look, 3 steps. Step number 1, identify new science. Thankfully, Tony Greenwald did this just now. He pointed out that we were going through an implicit revolution. If you're watching this on TV, apparently the implicit revolution will be televised. So we are going through an implicit revolution, and the point is this: we discriminate, and I mean in a very narrow sense. Same performance, worse score. Same potential, less investment. Same abilities, and yet more environmental interference in your ability to execute in a college, in a school, in a daycare. We discriminate without intent without awareness. That is what we've just learned from 1985 to now. I want to underscore that this information, this updated knowledge, is deeply probabilistic. It doesn't tell you specifically who's going to do it, in what iteration. It gives you probabilistic knowledge that generally, especially aggregated over large groups of people, this is what tends to happen and we can measure it at that size. But the probabilistic nature of knowledge makes it a little bit trickier, and again, the law is most comfortable with very clear A hit B in the jaw and B is suing A for relief. There's not that much probability on whether or not a punch was thrown and a jaw was broken, but once you go into uncertain forms of probabilistic scientific knowledge, things get harder, so I wanted to flag that. So I'm not going to repeat the new science, I just want to posit that it's there. Step number 2, excavate old law. Now I could do this for hours, I have 35 minutes. Let me try to focus on some things. I think it's fair to say that federal anti-discrimination law is fixated, arguably obsessed, with conscious intent. What do I mean by conscious intent? By conscious, I mean self-aware via direct introspection. That means you can close your eyes, you can ask yourself, why did I do it? Okay, I know why I did it. I might not tell other people, there are cameras that are rolling right now, I might need 7 beers before I actually explain the truth, but I know why I did it. It is subject to my ability to introspect and get an answer. Moreover, intent is purposeful. That means you're motivated to act because of the racial consequences, not in spite. The racial consequences themselves, whether you're trying to hurt black people, help Asian people, hurt white people, the racial consequences themselves provide the justification for your action and are not just a regrettable side effect, right? This is what I mean by intent at the most purposeful level of sort of mens rea. It's not surprising that this is what anti-discrimination law is obsessed with, because think about when the Equal Protection Clause was passed after the Civil War. Think about when the Civil Rights Act was passed in the 1960s. This was the threat model. When people were racist, it wasn't as if you couldn't tell. It was politically correct to be politically incorrect. And so the point is, it makes sense the law responded to the most obvious problem, which was this. Now you see this, quote, fixation in multiple areas. And again, being in some ways a law professor, I'm going to actually teach you some law and show you some language on the nature of fixation and then move on. First, we see it in the Constitution. People talk about equal protection of the laws. It's always useful to see the actual text. 14th Amendment to the U.S. Constitution, after we fought a bloody civil war. The end of Section 1 says, "Nor shall any state deny to any person within its jurisdiction the equal protection of the laws." That's all it says, equal protection of the laws. That phrase, as grandiloquent as it is terribly vague and must always be operationalized. And lawyers are great at creating doctrine upon doctrine, rule upon exception to the exception to the rule. And we operationalize this grand concept of equality, equal protection of the laws, through a very complex system. Long story short, and I won't get actually onto the detail, the whole point of the game is to get to what we call strict scrutiny. For some governmental actions, we will actually give judicial review at the level of what we call strict scrutiny. And if you get to strict scrutiny, it's highly unlikely to survive. So the part of the game that lawyers play is to take a particular challenged action that the government is doing, whether it's a particular stop and frisk policy, whether it's a particular employment program, whether it's a particular affirmative action program, and if you want to take down that law, you have to shunt it off to, quote, strict scrutiny. And how do you get it there? It's this obsession with intent. Most important is this idea that if you demonstrate an intent to harm based on race, that's how you get to strict scrutiny. Just to be clear, it has to be because of, not in spite of. So in a case called Personnel Administrators versus Feeney, it makes very clear discriminatory purpose implies more than just intent as volition, ... It means that you were selected or reaffirmed a particular course of action in part because of, not merely in spite of, the adverse effects upon an identifiable group. And in cases like Washington versus Davis, the Supreme Court just emphasized, this is what we're looking for. We want really a conscious purpose to harm, say, racial minorities before we give it strict scrutiny. Because if we open it up even more broadly, like and look for things that are just about different impacts without this kind of evil intent that we're fixating on, maybe all hell would break loose. I think I could say hell, right? It's going to be on the internet. So all hell might break loose. Think about what the Supreme Court said. If we actually focused on a statute that served neutral ends and still called it invalid, what would that do? It could have far-reaching circumstances and consequences. It would raise serious questions about tax, welfare, public service, regulatory and licensing statutes. If anything that had a different racial impact would suddenly be struck down as unconstitutional, we might have to strike down everything, and we can't do that. Now, I know there's some people in the room who said, yeah, strike down everything. That's why we're here. Like, I thought the revolution was being televised. Yeah, that's what we mean to do. I understand, but trust me, 9 Supreme Court justices with Article III tenure and elite educations will never allow you to strike down everything. That is not the point of their jobs. So that's how they actually set up a particular way to trigger certain things onto strict scrutiny, but not others. I'll give you one other example, and it's not constitutional, it's statutory. We make a big difference in the law between the Constitution and just statutes that say Congress might have passed. In terms of statutes, Title VII of the Civil Rights Act, which Tony Greenwald cited to, says the following, right? It's a Civil Rights Act that was passed in 1964. In the prior lecture, Tony Greenwald pointed you to a provision that's called disparate impact. If you look at another provision, which is actually known as disparate treatment, it says the following. Again, as a teacher, I always point to text. This is what the law says. It says basically it shall be unlawful to do the following: to discriminate against any individual because of race, color, religion, sex, national origin. So if you discriminate against any individual because of these impermissible factors, then you will be violating this statutory provision. Under disparate treatment theory, and I know there's a lot of vocabulary, but it turns out that's how lawyers make a living. Under disparate treatment theory, what you ultimately have to show, presumably, is yet again this fixated intent to harm based on race. How do I know that? If you look up a standard Westlaw or Lexis treatise, and if you wanted to get up to speed on the doctrine, this is what they tell you the law is. Disparate treatment cases involve basically treating people worse than other persons. Proof of a discriminatory motivation is required, right? So what the legal resources, all the treatises, tell you generically is that in a disparate treatment case, just like in the equal protection context, what you need to do is to find conscious intent to harm minorities. Otherwise, we're not going to actually knock things down. It's not always this case. There is this other thing. I'm not going to go into great detail. I will talk about it later. There's another brand of or version of Title VII theory that's called disparate impact instead of disparate treatment. And there, intentionally, Congress made very clear we will allow some relief even though there is no conscious intent to discriminate, as long as there's a disparate impact and an employer can't explain why they picked these sets of procedures. I'll come back to that later as useful, but let me press on. Going back to the big picture, when you excavate the law, this is what we find. We find a particular threat model that is obsessed with conscious intent. You're the bad guy. You're the bad apple. On the weekends, you put on a sheet and burn crosses. I don't know what you do, but our threat model is there's one perpetrator who has an evil mind and an evil heart doing bad things to folks of color, and that's not right. That's unconstitutional if you're a state actor. It's illegal if you're an employer. That's how we understood and focused on the law. Now let's juxtapose the new science taught to us against the old law. The truth is, we've just learned that we discriminate without the intent to discriminate and without the awareness that we're discriminating. That means if we look only for conscious intent, we will necessarily be blind to a whole bunch of real harm that's painful and consequential. How do I know that it's painful and consequential? Of course, Tony Greenwald told you so. He had a PowerPoint slide. But there's more, and it's kind of odd that I'm going to show you a little more numbers than a professional psychologist, but crazier things have happened. In psychology, people talk about not only whether something can be demonstrated to be statistically significant, people are increasingly interested in what we call effect sizes. Like, you say implicit bias might lead to more awkward body language. You say implicit bias might lead to slightly different kinds of force used when cops deal with young African-American men. You say there's some connection, but like, how much of a connection? Like, sure, I get it. It was enough to publish the article and you got tenure, but it is a lot or just a little, right? Because it matters, because there's a lot of stuff. A little, just a little, right? We've got a lot of things to worry about. It's just a little. The way that scientists try to figure out whether it's a lot or little is to canvass the entire literature. They are not like lawyers who won't mind a 50-page memorandum describing all the different studies, say in 50 different states, or all the different laws. What they want, scientists, let's face it, they like numbers. They want one number, right? They don't want to read 50 pages. They want one number. So what they do is they take all the studies, both published and unpublished, create essentially standardized effect sizes for each of the studies, weight them roughly by the number of subjects that were run through each study, such that a study that had 3,000 people versus a study that had 30 people, you would weight accordingly, and you stitch it together to get one number. When you do that, Greenwald et al., I was not part of that all, he didn't invite me. I didn't have the credit, regardless, I couldn't help. But the point is, in 2009, Tony Greenwald produces the first meta-analysis of effect sizes. And he comes up with a number. In sensitive domains like black-white behavioral domains, he comes up with a number, R, Pearson's R, a measure of linear correlation from -1 to 1. Like, what does this mean? He gets a number, R equals 0.236. You square that to get the percentage of variance explained, and by now your eyes have glazed over. It says something, it's a number, maybe you learned it, you promptly forgot it. Here's what's interesting, right? There are some people politically who don't like the idea of implicit bias. They think, yeah, come on, like really it doesn't exist. It's a tournament of merit. If there's a disparity, it's because the people at the bottom are not very good at what they do. Stop whining. There are a lot of people who are hostile politically, but also ideologically and also financially and also scientifically. When you get some such people into a room and have them write their own paper, this is what they get. They get R equals 0.15. R equals 0.15. Now again, you're thinking like, I don't know what, like, dude, I don't know what R equals 0.236 means. I don't know R equals 0.15. Like, it's obviously lower. That you can tell, right? 0.236 versus 0.15. I can tell that as well. There's two things that are interesting. One is, the nice thing about data is that they misbehave. What I mean is they don't actually follow blindly the commands of the person who collected the data. So you could say, if you're a complete cynic and skeptic, that Tony Greenwald would want to pump up this number all the way up to R equals 1. He created the test, you find the behavior, it's like a perfect diagnosis for racist behavior. In some sense, who wouldn't want a perfect diagnosis, right? A perfect test that gets everything right in a total linear correlation. But he only finds 0.236. Moreover, the people who are hostile and also work as experts defending large corporations who've been sued, right, would want R equal to 0. This is a crazy junk science test. I don't know why you're playing those internet games. He was probably lying when he was typing in those numbers. Those numbers were set up even beforehand. You've just been played. Whatever the reasons might be, you would want them to shunt it down to 0. But they are scientists too. And even though they make different judgments about what studies to consider, how to count, they can't push it to 0, just like Tony can't push it to 1. Science actually might be constraining our political fights in a particular way, even if not entirely. So here's a debater's trick. I'm just going to take R equals 0.15, the group that's hostile to this research, as the right answer. Suppose it's only that, whatever that might mean. The only way you can make sense of R equals 0.15 is to actually compare it against something you might have some gut feeling about. So I'm going to compare it to medical common sense. Questions? What do you think is the correlation, which is again a linear correlation between X and Y variables, between taking aspirin and reduced risk of death by heart attack? Some of you are popping baby aspirins right now as we speak. I hear it. R equals 0.02. Chemotherapy and surviving breast cancer. I'm not going to joke about that. R equals 0.03. Ever smoking and lung cancer? I tell my kid, don't smoke, man. Bad for teeth, you'll get lung cancer. R equals 0.08. Again, their number hostile was 0.15, twice essentially of this rate. I sat down to a lung expert, with a lung expert at UCLA. Come on, is that right? Is that right? And she said, yeah, it's kind of right. Even if you're about to die of emphysema, only 20% of those people get lung cancer. The truth is, most people don't get lung cancer. Most people who smoke don't get lung cancer. Most people who don't smoke don't get lung cancer. So knowing that you smoke doesn't tell us a lot about whether you get lung cancer. It is what it is. I'm not changing my tune for my daughter, though. I'm just not telling. Alcohol use during pregnancy and subsequent premature birth, R equals 0.09. Low-level lead exposure and reduced childhood IQ, R equals 0.12. It's lower than what the hostile group find. Now, if I see a kid in the corner sucking on paint chips, I don't care if it's my kid or not. I'm not doing an analysis, I think this house was built after 1976, the EPA restrictions were being enforced, have at it, suck on the paint chips. No, I take the paint chips out of the kids. You should not be licking paint. I don't care if it's leaded or unleaded. It's not a good thing. Why? Because I guess it's my folk wisdom about the causation of some stimulus or input and some outcome. But we live every day, like how much you're boozing it up, how much coffee you're taking, whether you're taking aspirin, whether you would let your kid lick paint. It's like, well, I saw the R's, and so, yeah, I don't think implicit bias. I'm not biased. Lick the paint, kid. You wouldn't do that, I don't think, right? So I just want us to own up. Right? To admit what we do and why. And when we demand scientific certitude, are we demanding equally from all sides? Or are we all just a little bit motivated, such that inconvenient facts we ask more of? Final point about cumulative disadvantage, which is one way to think about these effect sizes when they add up over and over again. This is actually a stylized example that actually comes from Tony Greenwald and Majan Bernanke's book, Blind Spot. But I do it in the context of a law firm partnership. Imagine the following. Greg and Jamal are associates, and they're competing for the prize of partnership, right? Suppose that this is not how actual law partnerships work, but suppose basically it's an up or out decision every month, right? But to make it a little bit more plausible, it's very easy to go up each month. There's a 99% chance that you'll be promoted and allowed to stay on for next month. And if you can survive for 8 years, you get the prize of partnership, right? You get more pie, if you know the joke. How do you, the prize for a pie-eating contest, more pie, yeah. So the point is, suppose these are the facts. Suppose further that implicit bias just changes one's success rate by only 1%. 1%. What this would mean is that Greg's chance of monthly promotion is 99.5%, Jamal's is 98.5%. By the way, Jamal's black. Just a little bit. At which point, old school civil rights people will say, Jamal, 98.5, shut up, stop complaining. When we were fighting the good fight, it was much harder, right? People are not throwing things at you. People are not there's no dog sick on your laptop. 98.5, good enough. Don't complain. That's exactly how my dad raised me. I'm an immigrant, first-generation professional. When my dad said, you have to be twice as good as the Yankees to survive, he was not talking baseball. He called white people Yankees, right? He said, you just have to be twice as good. I said, okay, twice as good, okay. So the point is, it doesn't seem like a lot. But here's what happens after 8 years. If these are independent probabilities every month, 99.5, 99.5, 99.5%, then you would raise each of these rates up to the 96th power. I know this is not how life actually works. What's Greg's chance of survival after 8 years? It's 0.995 raised to the 96th power. 96 is because we have 12 months times 8 years. 8 times 12 is 96. And then here's the answer. It's about 62% chance of survival. You know what Jamal's chance is? Just 1% less. Just a little bit less. 23.4%. How is this possible? It's the power of compound interest, which is why all of you, especially the young people, should invest in your 401k plans immediately. It turns out little decrements over a longer longitude matter a lot. So every time you shake a hand, every time you pitch a business deal, every time you try to close a deal, every time you perform ambiguously, little decrements integrated over an entire lifetime, and then you double integrate that, not only over the longitude of time for each individual, but across all individuals, across all black people, and across all white people, it turns out you might not need that much to cement inequality that we never wanted, never bought into, but nevertheless entered into the stream of because we were born into that which we call America. I'm not saying there isn't stone cold racism, right? Whether you call it race, like stone cold. Just read anonymous blog entries or anonymous comments on anything dealing with race. You just see the stone cold stuff coming out. Like, who needs the IAT at some level? But that picks up what we call covert explicit bias. People know they have it. They're typing it. It's not like, like the spirit caught them and they're typing all the smack in the comments anonymously. They know they have it. They're typing it. But that's covert explicit. We're talking about implicit. You don't even know you have it. But what I'm saying is even if you cabin aside the stone cold but often covert explicit racism, even if you cabin aside what we call institutional or structural stuff, that has in some sense nothing to do with disparate treatment at time zero, but has something to do with where the highways were laid out, right? How food is distributed, right? In modern cities, all kinds of more subtle and structural forces. Even if you cabin those aside, implicit bias, as measured by an instrument like the IAT, could explain enough of why there's still discrimination in our house, why it seems like a coincidence all the time, and yet it happens all the time. You don't need necessarily more to explain the disparities that persist. If this is so, and I have 15 minutes left. If this is so, right, what shall we do? What I'm trying to suggest is there are real harms. Like, I don't care about what your politics are, left or right, Democrat, Republican. Like, if you believe in anti-discrimination, if you believe same performance, same score, and then there's this overwhelming amount of evidence that says because of junk in our heads, whether you call them implicit attitudes or implicit stereotypes, on the margins, we're not as fair and square as we thought we were, as fair and square as we would like to be. What are you going to do about it? Can you change the law accordingly? There are objections. I'm not going to deny that there aren't good objections. I'll run through some of them, but I won't have time to go through all of them. Look, there's all kinds of objections. You're like, well, I didn't know I was discriminating. Well, I get it. I get it. If you knew and did it, and you did it purposefully, there could be worse kinds of responses. But in first-year law school, you quickly learn that there are different types of culpability. We call this, from the Model Penal Code, purposeful, knowing, reckless, and negligent. If you're a contract killer where you got $10,000 to knock off someone, we get it. That's worse than being a negligent driver and killing someone. I get it, 2 people died, but we understand that purposeful contract killing is actually worse than just being a bad driver. We understand that. That doesn't mean we can't process negligent homicide. We get it. We get it. You didn't want to shoot the guy. You made a bad mistake. There should be consequences, right? There could be consequences. So we can actually do that. You can say, oh, but it was probabilistic. How do you know that I did it in that particular incident? I get it. There is no certainty in particular cases, but life is full of causal uncertainty. If you live next to a nuclear power plant and you get an uptick in base rates of leukemias, I get it. You can't tell which leukemia, right, was caused by which radiation leak, because there's always a background rate. That does not mean that we as a society have to be blind to the fact that there's statistical evidence that there is an uptick that we should do something about. You could say, I'm just a robot. I could not have done otherwise. Implicit bias is everywhere. That's what Tony said, so it's not my fault. Well, maybe that's so, in which case you have a puppet defense. A philosopher would say strict determinism. But the truth is we could do better. We can do better. And it's frankly science's obligation to provide better and best practices which can identify how it is we can do better. And that is clearly the next wave of research that we're all interested in doing. It is not as hardwired as you think it is for all kinds of reasons. Finally, there is this anxiety that lawyers always bring up of no limitation principle. If you say, look, you told me everyone's biased, like, Tony Greenwald says he's biased, you are likely biased, that means we're all biased, and that means bias leads to behavior, that means we're all liable, everyone has to pay out. Everyone has to pay out. I can't live with that. Everyone has to pay out. I understand the anxiety. Like, you can't make everyone liable for everything, right? I'm a lawyer, I'm a pragmatist. I work at a professional school. I understand the need to be pragmatic, but again, proportionality in response is possible, right? There's lots of things, for example, that allow forward-looking remedies. I'm not going to pay you punitive damages or even compensatory damages, but I will give you injunctive relief that forces this person to fix the problem, right? So just think about this. It doesn't even have to be dollars. Scientists say we've got a set of better practices, given the fact that there's implicit bias-actuated discrimination. And we've offered them to the public domain for free and not very expensive to actually implement. Employer or the state steadfastly refuses. I'm going to do it. Ain't going to do it. Ain't going to do it. Not going to do it. No, no, no. And then bad things happen. At that point, why can't you sue the state or the employer and saying, look, there are better practices. You could have avoided implicit bias-actuated discrimination. We're suing for relief, not even for money. Just adopt the better practices. Proportional. Not about everyone being paid out, and actually fixing the problem going forward. You don't think smart lawyers could create those kinds of solutions? Why not? I mean, if the lawyers are not smart enough, why can't you fix it in that way? So what I'm saying is, notwithstanding the fact that there are objections, I'm trying to be reasonable and say that there are reasonable ways that we as a society can press forward. I have only about 11 minutes, so let me talk a little bit about strategy. That's a little bit's going to be doctrinal, and the other part is actually going to be more about the nature of essentially what might be called a duty to be intelligent. More on that later. More on that later. Here's a strategy. I'm not going to, since this is not a legal audience, I'm not going to talk that much about the strategy with courts. I'll give you just one example. Remember I said that constitutional law, Equal Protection Clause, and disparate treatment theory under Title VII of the Civil Rights Act was obsessed with this conscious intent. It turns out if you really look at Title VII, even the disparate treatment provisions, it doesn't actually say intent. It just says because of, right? It doesn't say you have to have the conscious intent in a sadistic kind of way to hurt black people or Asian people or American Indians. It just says because of race. It's not actually about intent. It's all about causation. And there are cases that increasingly identify this as an explanation. So I'll give one case called Kimball. It comes out of the Eastern District of Wisconsin, 2010. And this judge makes clear, right? Nor must a trier of fact decide whether a decision maker acted purposively or based on stereotypical attitudes of which he or she was partially or entirely unaware, right? So it could be that you're based on unconscious or implicit stereotypes. It says rather in determining whether an employer engaged in disparate treatment, the critical inquiry is whether its decision was affected, right? Caused. Did it have an impact? That's all we care about. So you have at least some courts who are saying, hey, I've looked at the statute. I know we used to always think it was about conscious intent, but the text doesn't require it, and smart people are telling me that discrimination happens through other mechanisms, so I will read the statute accordingly. So it's possible to read the law in a way that is more consistent with what the best mind science tells us. Now, to do that, however, you do have to get the mind science in front of the courts, and that in itself is tricky. I'm not going to go into the drama, but you should know that's Tony Greenwald. It's from his website. I did not ask for permission. So huge battles about the admissibility. It's a very good picture, though. Huge battles about whether to allow expert testimony are being fought right now. There's a whole complex set of rules under the Daubert Doctrine, under the Federal Rules of Evidence, that allow certain kinds of expert testimony to come in or not. I should just tell you there are cases in which this man's testimony is actually admitted, in other cases where this man's testimony, probably the same brief, is not admitted. So lawyers are fighting about it, and it's actually a grotesquely complex play that I'm not going to actually ruin your evening with. I do have to suggest, however, that there is some obligation to be consistent, right? This is what it means to be transparent. You know, we allow, and the police officers know this, we allow a lot of forensic evidence to actually get people into jail. Fingerprint, bite mark, hair specimen, like weird stuff. Like, I'm not talking about DNA. The DNA stuff, I think, is a very different kind. But just even the fingerprinting stuff. It turns out that according to the National Academies of Science, 2009, there is a notable dearth of peer-reviewed published studies establishing the scientific basis and validity of many forensic methods. Everything you saw on CSI, lies. I mean, not lies. I mean, it was TV. You knew it was exaggerated. No one's that good looking in a lab. But we do a lot of stuff where we don't really have evidence for anything that we're doing. We're just phoning it in because it seems comfortable and seems exactly what we've always done. And so if you're a judge and you're going to say, oh, I don't believe this implicit bias stuff, there's no specific information on this, are you going to then say, when there's overwhelming evidence on eyewitness identification, especially cross-racial, that it's not very good? Are you not going to allow scientists to come in and say, you know what, everyone assumes eyewitness identification is perfect because it feels so gut-based, it feels so honest when someone says, he's the guy, he did it to me. When you look at the underlying evidence, that's terrible. The underlying evidence about the accuracy of this kind of identification is horrific. Are you not going to let that evidence in when someone's life is on the line? What kind of judge are you? How blind must we be? What set of moral commitments to an earth that is only 5,000 years old, to a justice system that must be right, must drive you so that you would keep that kind of evidence out? Why? At least own it transparently. Here's what's really interesting, and this fight gets much more dramatic with class actions for all kinds of reasons because more money is at issue. But what I want to suggest is that maybe the evidentiary fights, which are incredibly important, that lawyers are fighting about right now, maybe you could actually go beyond just the evidence and go instead to the zeitgeist. You know, that Kimball case that I cited earlier that made very clear that disparate treatment only requires causation, not conscious intent. There's a bunch of social science that comes at the end of this judge's opinion, her opinion. And she starts that social science discussion with this. Although my rejection of defendant's explanation is a sufficient basis for finding liability, I will discuss other aspects of the case because I believe they help to provide a fuller explanation of the challenge decision. Yes, the lawyers amongst us know that this is the grossest form of obiter dicta. Yes, it doesn't have to be in the opinion. You shouldn't write it. I understand that. That said, she has pages that cites to law reviews, scientific articles, and I pulled the briefs just to make sure. None of that was briefed. None of that was written and sent to her to cut and paste into the footnotes. She did it herself. It had entered the zeitgeist, the common sense of this judge's mind, and therefore the explanation goes differently. Here's another case, McReynolds versus Merrill Lynch, and after this I'll roll into a conclusion. It's a Title VII class action case, disparate impact. It happens after a case called Walmart, where it seemed like it's going to be very hard to have these kinds of class actions. Long story short, a class action is certified. In the certification, here's what the judge writes. These teams at Merrill Lynch, these are broker teams. They create their own teams to decide how they're going to actually sell their book of business. The teams, they say, are little fraternities. Our term, but their meaning. And as in fraternities, the brokers choose as team members people who are like themselves. If they are white, they, or some of them anyway, are more comfortable teaming with other white brokers. See in-group favoritism. They didn't cite to it, but that is what it is. There's obviously bound to be uncertainty. People tend to base decisions on emotions and preconceptions for want of objective criteria. Implicit, unconscious, no citation to Tony Greenwald's work. I'm okay with it. He continues, vicious cycle, that if you do this, including inheriting books of business from other people who retire and then give it to other people, it creates a kind of vicious cycle. In turn, it helps a broker do well in the next round, the spiral effect attributable to a company-wide policy, disadvantage to black brokers. It's a story of cumulative disadvantage. There's not a single social science article that's cited. It's just this judge's common sense. You know whose common sense it is? It's Richard Posner. Now, Posner, I get it that as he, he's changed his tune in some ways, and that's interesting. He was also the guy who publicly said, I don't know why Korematsu was wrongly decided. Why is it wrongly decided? He asked. He didn't have an adequate answer. But he's saying this. When you have The new director of the FBI talk about implicit bias, right? Back in LA, we say, hey, that's jumped the shark. We know that that issue, that idea, that concept has gone, for the younger folks out there, sufficiently viral such that it's actually entered the zeitgeist of people's minds. And it might not matter that Tony's expert testimony gets kicked out right now, because inside of 10 years, everyone will know that our brains are complex. Here's the conclusion. I said arc of intent. It traded on a speech that Martin Luther King gave back in 1965. And he said, somehow the arc of the moral universe is long, but it bends towards justice. And even though I am being, of course, naive, and the sophisticated sociologists of knowledge will come back after me after this talk, I want to also talk about the arc of truth. Somehow the arc of human understanding is long, but it bends towards truth. And the truth is inconvenient. We are fallible, but we can do better, and scientists can and should help provide that toolbox. And when they do, we as lawyers and citizens must use these tools to keep the arc bending toward justice. Thank you very much.
That's wonderful. I see why you get on this teaching meeting. At this point, we can open it up for questions. If folks want to also, again, move to the microphones, that would be helpful. And again, we have microphones in each aisle over here. So.
And it's been a long night. I won't hold it against you if you want to exit immediately.
Okay.
Which they are doing.
No.
You mentioned some policies that employers could easily adopt. Can you name at least the top 3 or 4?
That's a great question. So I think you can tell I think like in categories. I can only remember about 3 or 5 things. So I think about things in terms of assessment, investment, and environment. So one is, how can you more accurately assess people? Tony Greenwald talked about essentially selective blinding strategies. To the extent possible, if you can blind yourself from social demographic data that will actually lead you to confirm your biases, you should blind yourself. I'm a big fan of blind grading when possible. Another example is actually what I call appellate review. There's great reason to think that if you're held accountable for your decision making, oftentimes because people are counting what's happening afterwards, if you are held accountable, then you will actually be more careful and not phoning it in. So I would include in the assessment strategy selective blinding where possible and greater accountability by having appellate review. You could either count results or you could periodically do blind appellate review. You could allow people to grade. Like imagine senior associates have graded junior associates' work, but just have a roving quality control committee that will randomly pick one piece of work every month, blind the name, send it to an independent third party who reviews how good the memo is. I get it, if you're not the supervising attorney, maybe you don't know all the facts, but you certainly can tell whether it's a good memo, just in terms of basic legal analysis, in terms of basic ability to write grammatical sentences, organized in the right way. If the blind review gives an A, but actually the supervising attorney gave a C, red flag. Vice versa. If you, as the blind review committee, give a C, but he was given an A because he went to the same football team that I did kind of thing, USC, Trojans, whatever it is, then that's another red flag. So that's in the assessment strategies. I have views about how to develop human capital investment, and I also have views about how to set the environment correctly, but I've been speaking too long. So those 2 things at least.
Go ahead.
Oh, sorry, it's a teaser. Sorry, spoiler. Yeah.
The gentleman before asked a question about when we realize that we have these kind of biases at hand and we become conscious of them, is that a movement towards progress and a better understanding and treatment of people? Yeah. And Dr. Greenwald thought very long and hard before saying, I think that it is. And I wanted to probe that a little further and ask, if we have this implicit bias and all of our structures for our legal structures and employment structures and EEO and affirmative action and those sorts of things are based on a conscious bias and trying to correct that, are those in fact counterproductive to actual progress in the face of implicit bias. And what people say is that this is enough. We've taken care of this. We've addressed the issue, and we don't need to do any more.
Yeah, so I just want to make, so I think I'm going to respond, but then if I miss something, I want you to follow up. So on the original question, whether kind of being more mindful and so I do agree that if you have the threat model wrong, then your solution set will always be off. So again, if you think the attack is only conscious intent, then your solution set will never actually deal with the fact that there's also implicit bias-actuated discrimination. So if we think we're done, we've got lots of problems that continue. Now, the original question that was asked of Tony Greenwald was, well, is being made aware enough? And Tony Greenwald suggested there's skepticism about just being told that biases exist. And so generally I think about it this way. There are some ways to debias, which is decrease our biases. It turns out being exposed, for example, to countertypical exemplars will actually decrease your bias. Like I think I do permanent damage to my civil procedure students because they don't associate this face with law, maybe engineering, maybe physics, but not, or East Asian languages. But with law, I mean, this is not the face you expect to be your civil procedure teacher. There are permanent associations between law and East Asian face, I think, have been rejiggered. So if you expose yourself constantly to countertypical exemplars, you could arguably change the underlying implicit associations in your head. But more important is you want to break the linkage or the causal linkage between the bias and the behavior. This is why all the people in the game really are interested in structural transformations. Can you get changes in the policies and procedures such that even though people still remain biased, because you're constantly infected every day you watch TV, every time you go outside, every time you just observe the world, which is unfair, that you see every day, can you nevertheless adopt strategies that make us better at interviewing, better at reviewing documents, better at setting up an environment that's less hostile for certain kinds of people? So in that sense, I agree with Tony Greenwald. I also agree with the statement where you say, like, if we think that, again, attending to explicit bias, explicit conscious intent, has solved the problem and we've gotten past it, that misses an important part of the game that will continue to fester.
Go ahead.
Yeah, I was wondering, how, in your experience, how far behind the science does the law lag? And if that's something that has improved as the spread of information has become faster, or has stayed the same because there's more bad information available as much as there is good information, and
Yeah, so
people get more entrenched?
That's a great question. So like I have to be upfront, like as a full-time research academic in a fancy research university, there are a bunch of people who do sociological, both deep and strong and soft critiques of the nature of science and the discourse of scientific exceptionalism, such that people say, no, it's not that law is slower than science. Actually, law is faster than science, and it'll be flipped in a thousand different ways. Putting that aside, which there's sometimes some interesting aspects of it, I think there is a delay. It's actually been tightened up. It's much less a delay than you might imagine. Microeconomic thinking, what we call law and economics, has been dominant in legal education for the past easily 30 years. And the kinds of economics that we used explicitly and implicitly in law school was kind of Mickey Mouse economics, but it took 30 years for us to figure out that fancier stuff was available. And so there was this almost 2-decade gap in the best economics that was being done and what we thought was orthodox in law schools. With experimental social psychology, I think that has actually decreased by some of it by like 3-6 months. Like many of us read, again, papers before they're even published because we're connected with the scientists who do the research. So there's been an acceleration. But you were smart to identify the last point. There's conflict, right? Not only amongst the scientists, but then amongst the lawyers who are allies with the scientists. And if you thought that somehow, well, science will just give us the truth, I mean, that's the scientific method, right? That's what we learned in biology. Hypothesis, experiment, data, no, they hate each other. There's a lot of motivated reasoning, even in the sciences, which make it such that even full-blown scientists accuse each other of either just this side of really bad behavior or being so politically one-sided such that real science can't be done. And there's dirt being thrown everywhere, and we lawyers are just kind of confused, like, wow, we thought we were the problem, but when you actually see the sausage being made among scientists, it's like, yeah, glass houses, remember that. And so, given that fact, there's conflict. It's not because the policymakers and the lawyers are reading stuff 15 years ago. We now have Google and stuff, and so now we're reading Google Scholar. We're reading stuff almost as it comes out, right? So it's actually been much quicker. But because it's been much quicker, it hasn't reached the steady state consensus, right? They're still fighting over effect sizes. They're still fighting over psychometric properties of the IAT. They're still fighting of all that stuff. And so it's hard to translate that because there still isn't entire consensus. Final point, that's it. FBI director,